Good afternoon and welcome back for the last session for the day. I am going to discuss in this session the taxation of e-commerce and cloud computing. You might find that there is some overlap between my presentation and what Rashmin Sanghvi spoke in the morning. He was on a very macro level and perhaps a philosophical level as to who should get the right to tax and what are the challenges in that. I am going to cover certain live cases or live examples of situations where it is highlighted that the rules which are currently in force are inadequate and therefore there are difficulties, and the extent of the inadequacies of the current regime will be highlighted during the course of this presentation. And of course, I will go through a gamut of the different types of e-commerce or digital economy transactions. I will also touch upon briefly the BEPS report and what is the current status of that, especially in respect of e-commerce, which is action point number 1. I have put on this slide Intel inside and we all are outside, but basically it is not to offend any of us, but this is sometimes what really we do. It makes it appear that what we are doing, whether are we doing the right thing or whether we should be doing something better. So there is no offense meant for anybody. Transactions over the internet have increased tremendously in volume as well as in terms of quality of or the nature of transactions. E-commerce involves transactions over the internet generally without the need for human interface, such as e-advertising, e-sales, e-delivery and so on. The volume has gone up from $2.5 billion in 2009 to $14 billion in 2012, and in 2014 it is even more, and it is going at an exponential pace. And this growth has intensified discussions on the taxability of the transactions, especially what remains still under a cloud, that which countries should tax what portion of the income, because ultimately the income by one SSE is what we realize is less what is his cost. Then we have a maze of structures. Some portion of income we say arises in Ireland, some portion we say it arises in Bermuda, some portion arises somewhere else, and finally we say that I am an honest taxpayer and I will pay only 30% tax rate, full tax rate I am paying on the $10 which I am leaving in the company. So that is what is really sort of aggravated the problems. And Rashmin Bhai spoke in the morning of the financial crisis in the US and Europe, and how this has actually forced the G4 and now part of the G20 mandate to the OECD to come out with a solution. In 1999, the OECD has set up a rule to examine the applicability of the business profit rules in e-commerce and to propose any alternates if required, and the OECD came to the conclusion that it did not justify any significant departure from the existing rules. In 2001, we saw that the committee of which, high-powered committee of which Rashmin Sanghvi was also a part, also came to the conclusion that the tax differential tax treatment will offer a easy tax avoidance mechanism. If you give a differential tax treatment, what is going to happen is that you will lay down certain rules, and if you lay down rules and formulas, it is easy for the consultants and corporates to design structures and stay out of that. And therefore, there has been no real conclusion either in India or in OECD or in UN on this subject. Now, why this problem? Problem is basically with the rules relating to the items like permanent establishment. In respect of e-commerce transactions, what constitutes a permanent establishment is a subject of discussion. OECD commentary on model convention gives some reasonable guidelines on what is a permanent establishment, and it says that a website is not a permanent establishment. Why so? Because it fails the traditional place of business test. There is no physical place of business to which you can connect a website. What is a website? It is a combination of software and electronic data, and it is not a tangible property at all. You can have a website on a server. Server might become a permanent establishment under certain circumstances because it is a physical server, and The moment you say that a server is a permanent establishment, all the servers in the world will go to places like Bahamas and Bermudas, because that is where there are no taxation, and that is where they would like to attribute the maximum income in respect of those servers. But be that as it may, OECD is quite clear in the, at least till now it is clear that a website is not a PE, but a server may constitute a PE. So this is where the challenges are beginning. Now under the BEPS initiative, OECD is again examining the issues, and as we know there are an action plan of 15 points, and item number 1 of those 15 points is to tackle the issue of taxation of e-commerce transactions. The OECD has set a very stiff timeline for this BEPS project, because it is doing it under the pressure sort of the G20, and it is not just the G4 or only the OECD, but the G20 which is driving this, and therefore chances of this project seeing the light of the day are much more than the other projects on this topic or any other project of the OECD, because there would be different forces which will have different interests, but here the G20 plus the OECD interest is to somehow try to curb the taxation, the issues arising out of the BEPS matter. The OECD came out with in respect of this action item number 1, it came out with one draft report in February 2014, invited public comments. The industry, the draft came out much earlier. The industry feedback was received in December 2013, and if you reach the industry feedback is that they want status quo to continue. Means Rashmin Bhai mentioned that there are some 400 responses to the plan on the OECD website, and if I went through a few of them, some of them are from banks, some of them are from IT companies, some of them are from different companies, but ultimately the common thread in all is that they don't want the situation to change, because obviously they are happy the way things are, because if there is confusion they would continue to pay lower tax, they will continue to shift the profits wherever they want to shift the profits. So they want the old wine in new bottle to continue, so to say, because that is the way they will continue to benefit from the confusion. The UN of course has a issue of resources. As a side remark, I can mention that OECD has got a tax team consisting of more than 100 people, which decides the OECD, which will go into different aspects of the model and the commentary and different projects of the OECD in respect of tax, like the transfer pricing team and so on. Any guesses of how many people are there in the tax team of UN? Any guess, wild guess? You are 10 times more than the actual. There is one person. And therefore, obviously there is a bandwidth issue with the UN, and therefore all these meetings which are happening are basically at the cost of the people who are attending the meetings. Means for the members it will be met by the governments, but for people like me who attend as observers, it is at our own cost. On the one hand, we say that OECD countries are also part of the UN, and if they can contribute so much to the OECD, see, after all these are public bodies, so they will need resources to function. So if OECD can afford 100 people in the tax team for their own model, so to say, the same members being part of the UN, there the contribution is much less, and therefore we have only one person in the tax team. So that shows the interest of both the parties so far as the development of the tax law in the, because they know that the UN model is likely to promote the source based taxation, and they are interested in the residence based taxation. So the interests are apart, and therefore they will continue to support the OECD, and they will not give the same kind of support to the UN. Ostensibly they say that if there are 200 countries in the UN, why should we pay more and why should we pay less, why should the others pay less, and so on. So ultimately, be that as it may, this is the situation, and therefore because of this bandwidth issue, the UN has not even started to look at the e-commerce issue. at the last meeting, it was decided that we will look at the e-commerce issue from October 14 onwards, because by that time in September 14, the BEPS report of OECD in respect of this item is expected. So they said that OECD's work, let it complete, and then we will take it forward and try to tweak it or modify it to the extent they would desire to serve their purposes. So that is the way things are. And till that time, whether the OECD, whether the BEPS project comes to a conclusion, whether it sees the light of the day or not, and whether the UN comes out with something different, something same, till that time what is going to happen, each country is going to have its own rules and try to tax what it considers its fair share in the tax pie. And therefore there could be cases of double taxation, double non-taxation, and so on. So we will go through some of these examples in fact I have got the BEPS report, what is the summary of that, but I think that will take up at the end rather than, let us first analyze the issues at hand and then we go to how the BEPS project is trying to analyze it. So basically the question is how to apply the existing rules. The rules were made in the time of brick and mortar economy, and today we are having the click and order economy. So whether the rules made for the brick and mortar economy will apply to the click and order economy is something, obviously they cannot be the same rules, but till there are a different set of rules, you will have to apply the same rules, and therefore this challenge is there before all of us. What is e-commerce? E-commerce has been defined broadly by the OECD working party on indicators for the information for the society as the sale or purchase of goods or services conducted over computer networks by methods specifically designed for the purpose of receiving or placing of orders. The goods and services are ordered by these methods, but the payment and the ultimate delivery of the goods service do not necessarily have to be conducted online. So this is how the e-commerce has been defined. You do the ordering and therefore the sale and purchase is through the internet, but delivery is physical and payment obviously has to be physical. So this is how the e-commerce has been defined. This was of course few years ago. Now we have moved much beyond that. Now the digital economy is much more than the e-commerce. We have got retail, or we have got the e-tail model. We have got transport and logistic business, which is also online. Financial services, like you can go to a website and purchase insurance online. You might, means in India, the FEMA prohibits you from taking a foreign insurance, but otherwise you can get an insurance from a foreign company also. Manufacturing, agriculture through advanced robotics. We saw the example of the doctor in the morning. Education is a field in which there is a lot of scope for e-commerce. There could be one professor giving a lecture at one place and it could be beamed on the, it could be webcast all across the country. I believe some coaching classes are in fact doing that, and they are multiplying their income. That is within the country, so we don't have the issue of cross-border e-commerce taxation. But otherwise, suppose the Indian professor was to take up a class in, let us say, forget USA or UK, but even in a country like Sri Lanka or Bangladesh, there will be cross-border, whether there is a income which is arising in Sri Lanka or it is arising in India. That is something, these issues need to be discussed, debated, and some policy be laid down for that. So first is the challenge under the domestic law about the taxation of such types of incomes, and then you try to apply the treaties. Treaties are already there. Treaties were negotiated n number of years ago, and they were obviously again based on the brick and mortar economy. Now you are trying to apply those treaties to the click and order economy. So old concepts of taxations may no longer be relevant, particularly under the treaties, and there is lot more than mere selling which is happening through the internet. Characterization of payments is a very vexed issue, whether the income is a business income, whether it is royalties, whether it is fees for technical services. We have been reading a lot in the papers nowadays about bitcoins. Now whether bitcoin is a currency or an asset. An individual might earn some bitcoins. Means online you can go and means even today Reserve Bank has not prohibited use of bitcoins in India. So somebody might go online and purchase some bitcoins, or he might earn them on some game, and he may store them on some server somewhere and use them for making some transaction. Now whether these bitcoins are his currency or whether they are an asset, That is something which has not even been debated so far, in India at least. Because we have got separate rules of computing of income in respect of currency and separate rules for assets. Sorry. In India, currency under the Reserve Bank Act has to be issued by the government. So obviously they are not currency. So they are an asset. So if you earn, let us say, 100 bitcoins, how do you value them and offer them for tax? And whether when you pay for something in bitcoins, how you do the withholding, if withholding is applicable. These are issues which are definitely going to come up over time. And therefore, there are lot many issues, whether the server or a website, whether it is a fixed place of business. We saw the OECD view, whether that view is binding to the Indian courts, whether there could be a better view. UN, the OECD, India and other countries have, the courts have expressed their views on e-commerce taxation. Each country has got its own set of precedents, and each country says that the income is arisen in my country, and therefore because the source of income is in my country, and therefore I should be having the right to taxes. So there is no solution found for the source taxation. What has actually means, if you look at the definition of e-commerce under the OECD, that a mechanism of ordering, placing orders of goods, sale or purchase of goods or services over the computer networks. So if you look at that, basically the argument of the people in the OECD is that because of e-commerce, what has changed is only the method of doing the commerce. Earlier people used to meet and do the purchase and sales. Thereafter, because of the telephone, they started ordering on the phone. Thereafter, they started sending faxes and giving the confirmations of the orders. And now you do that by emails. So what has changed? So one of the foreign speakers where I was attending a seminar, he said that when President Lincoln and his wife had gone for a play, and during the course of that play, President Lincoln got assassinated. Means that was a event at which he was actually assassinated. One of the press reporters then went to Mrs. Lincoln and asked that, how did you find the play? Lady obviously said that, you know, the president was assassinated. Yes, ma'am, but other than that, how was the play? So here the question is, the entire business model has changed, and they are saying that mere method of ordering has changed. Other than that means everything has changed. The entire life of the president has gone, and here means the entire the way the business is being done has changed, but still people are saying that no, what has changed is merely the method of giving the order and nothing else has changed. You are still passing the money through the bank, and therefore nothing else has changed. Still goods are physically flying from one place to another. So what has changed? But actually if you look at it, everything has changed. And I will give you one or two examples to highlight this point. A foreign company advertises on the internet. An Indian company places order on the website of the foreign company. The goods are delivered FOB to the Indian company. We are informed that the website is on the server located outside India. Whether this transaction will be taxable in India? An Indian company places order on the website of a foreign company. The foreign company accepts the order on the website and thereafter sells the goods FOB to India, and obviously the payment is made by the Indian company outside India. Is this transaction taxable in India? Obviously not. And will it make a difference if the server is located in India, operated by an Indian internet service provider? Will it make a difference? What difference will it make? It is not going to make any difference, because ultimately the order is placed by the Indian company on the foreign company. Wherever the website is located, wherever the server is there, nothing is changing. Delivery is still taking place from outside India to India. Payment is going from India to outside India. And whether the website is on a server which is at the disposal of the foreign company. These are all irrelevant matters. Once you look at the transaction and you take a view that this is a transaction of sale or purchase, and that sale has taken place outside India, payment is happening outside India, delivery is happening from outside India to India, and therefore nothing is taxable. So This is the commonest example which the OECD people will throw at you when they say that what has changed. Now, this example will tell you what has changed or what can change. Here also the foreign company sells the online products direct to the Indian company. The payment is made by the credit card to the foreign company. The foreign company instructs its agent in India to deliver the product. The agent stores goods in India on behalf of the foreign company. Any change? Goods are in India, and therefore it is, one will have to look at the facts and circumstances, but there is a strong possibility that there is a permanent establishment of the foreign company in India, and therefore that sale is taxable in India. So same transaction, but facts are slightly different, but that will change whether it is taxable or not taxable. The answer will be different. And this is what one can say, that this is what has changed. The e-commerce has changed. Earlier you could order maybe a container load of the goods. Now you can buy even one single number because the delivery is from India. Otherwise the cost of the transportation is prohibitive. But here logistics are taken care, and you can order even one piece and you will get it. In fact, I saw a small clip where Amazon has a drone of its own, and it will supply the material, even one piece they will supply by a drone from their warehouse to the customer's address, and the drone will land and you will get a message that your goods are outside, you come and pick it up, and the person who has ordered will go out and pick up the goods. They don't even need a courier anymore, leave aside a transport company. So things are getting advanced at a much faster pace, and technology being what it is, the tax laws will need to keep pace, and we know that it is a very difficult situation to keep pace. This is one simple example of sale of goods. Otherwise, what is happening means, if you have any questions, you can ask me at the right whenever the point arises. I don't want to wait till the end to give you time for it. So if you want to interrupt and ask questions, you are welcome to do that. What is happening apart from tangible goods, many intangibles are also passing through the internet. Sale of intangibles, know-how, copyrights, trademarks, everything can take place through the internet, and electronic ordering and downloading of the digital products. Amazon was perhaps the pioneer of digitizing of books, and you order a book and you just can download it. You make the payment by credit card and you download the book, and it is on your system, you have purchased the book. You have things like updates and add-ons to various softwares. There are certain limited duration softwares and other digital information licenses. Question is whether it is royalties or whether it is business profits. Because royalties, we have certain laid parameters that under certain circumstances, it can be treated as accruing and arising in India and therefore taxable in India. If it is business profits, you need to go back to the PE concept, and if there is no PE, you don't have any taxable income. So let us discuss another example of retail distribution through the internet. ACO is a company resident in state R. I think ACO gives away the name. I think by the time I come to the third or fourth bullet, you will be able to identify which is the company, ACO. It's an online worldwide distributor of tangible goods, which is mostly books as well as other digital products such as e-books, music, software, etc. It acquires non-exclusive distribution rights for the e-books, music and software from the copyright holders in several countries, and it sells the products to the consumers through its own well-known website. ACO's website is very much like a catalog, and it displays the entire range of the products offered by ACO and allows visitors to acquire these products online. Tangible products are then delivered through the independent courier services, whereas digital products are directly downloaded from the website to the consumer once the payment is confirmed. The mirror websites are hosted on a number of servers located worldwide. In large markets, ACO's preferred approach is to use dedicated server farms located in that country, and such server farms are located in a server farm owned by independent companies. In other words, the servers are not located in ACO's own premises. They are located in the server farm of an independent provider. Changes and updates to the software and data stored on the servers are done from state R by ACO's employees. So software updation, you have a new product, you want to change the price, you want to have a discount offer and so on. All that is handled through the software which is changed from the state R. BECO is a wholly owned subsidiary of ACO that is resident of state S. It owns and operates a warehouse where the tangible products sold by ACO are stored and from which they are delivered by independent courier services. BECO does not interact with the customers of ACO. BECO is remunerated on a cost plus basis. All emails and telephone requests to ACO are handled through a call center located in state R. So then with this background, let us discuss, is there a permanent establishment of ACO in state S? Any views? In state S, we have got a BECO which is storing the goods and delivering as per the instructions from ACO. These goods are delivered by independent courier companies from the warehouse which is rented by or owned by BECO. Ordering is done by independent customers directly on the website, which orders are received by ACO, and from there ACO tells BECO that you deliver item number so and so, 2 pieces to Mr. A whose address is as follows. BECO will pick up those 2 pieces and hand over to the courier company and send it over there. That is the job done. They are not bothered about the payment. Payment goes directly to ACO. Is there a PE? Whose sale? But the sale is not negotiated by BECO. There is the agreement or the transaction is between the independent customer and ACO. This guy is merely a delivery agent, so to say. So you can say he is a dependent agent so far as a delivery function is concerned. But for a dependent agent, you have 3 conditions to be satisfied. Is he satisfying those conditions? I would think not. Because he has to take some part in the negotiations, he has to take part in the contract, whether he has got a authority to conclude the contract. Are there royalties paid to ACO from state S? What is going to ACO? ACO is getting sale proceeds from individual customers. So there cannot be any question of royalties. So royalty is out of question. Are there any services furnished in state S by ACO? ACO is selling the goods from outside India to the individual customers. Are there any services, whether ACO is providing any services? Obviously not. And therefore there are these issues like PE issue needs some sort of refinement if you want to make this taxable in the state S. The law as it stands today, it will certainly not be taxable. Similar example, eBay, which is a reported case of the Mumbai tribunal. In this case, what has happened is that eBay Switzerland is a company which has got 2 Indian subsidiaries, eBay India Private Limited and eBay Motors India Private Limited, which are group companies. These 2 companies are providing market support services to eBay Switzerland and also payment collection services to Switzerland. In the earlier case, payment was going directly to ACO outside India, so to say. Here the payments are being collected by the Indian subsidiaries and they are being remitted to Switzerland. And what is the transaction? If anybody wants to sell something, then he can put it on an auction on the eBay site, which is an India specific site. It is ebay.in, though it may be on the server in Switzerland or wherever, God knows where. So these buyers and sellers, let us assume for the moment that both the buyer and the seller is in India. I have got a mobile phone second hand which I want to sell and there is somebody who wants to buy. So I will put up that mobile phone, I will put up the specifications and I will say this is the price at which I want to sell it. There will be an auction as per the procedure laid down on the website. There could be an offer and a counter offer. And finally, both the buyer and seller will click somewhere, I agree. And once they agree, the transaction is complete. payment will have to be made first, thereafter the delivery will happen. And eBay, what does eBay do? eBay provides a platform for doing this transaction. So payments are collected from the sellers. Payments are made to the sellers after collecting from the buyers. If there is a transaction is, let us say, 1,000 rupees. 1,000 rupees are collected from the buyer. After deducting some service charge, the 995 rupees or 990 rupees will be paid to the seller, and this work is done by the subsidiaries on behalf of eBay Switzerland. And these subsidiaries are remunerated on a cost plus basis. So eBay Switzerland filed a nil tax return in India because it says that I don't have any income taxable in India. It has operated India specific websites providing an online platform to facilitate purchase and sale of goods and services to users based in India. It entered into an agreement for marketing support with the two Indian subsidiaries, and eBay India was remunerated on a cost plus basis. These are the facts. Issue: whether the amount paid by the sellers to eBay Switzerland through eBay India from the operations of the auction sites are fees for technical services. Another issue: whether eBay India or Motors can be treated as a dependent agency PE in India. The tribunal has held that it has considered the definition of FTS under the domestic law and the treaty. In so far as India's treaty with Switzerland is concerned, the wording of FTS under the treaty and that under the domestic act is the same, pari materia. In other words, managerial, consultancy or technical services. So the tribunal took a view that by providing a platform, what eBay is doing, it is providing a platform for doing business, and it cannot be said to have, it cannot be considered to have been rendering any managerial services. If you look at three words, managerial, technical or consultancy, is the provision of the platform, is it a managerial service? Obviously the answer is no. Is there any technical service rendered? Obviously the answer is no, because there is no, it does not provide any technical services or other personnel in the entire process. What it is providing is only a technical platform where the buyers and sellers can meet and do the transactions. There is nothing, no technical services are being rendered to, provided to either the buyer or the seller. And is there any consultancy? Obviously there is no consultancy, because it is, nobody is advising. The eBay does not say that, okay, you buy this product, this mobile phone of Mr. Kapadia is a great piece, you buy it, it is, you are getting it at a cheap price. No, sorry, there is no such consultancy being done by eBay. It just displays the product, displays the features and the price, asking price. So neither managerial, neither technical nor consultancy, and therefore FTS was held not applicable. And if FTS is not applicable, where does one go to? Business profits. And for business profits, they will become taxable under the treaty if and only if there is a permanent establishment. And the department's case was that there is a dependent agency permanent establishment in this case. Submissions are that eBay India is involved in making awareness in India about the websites in collections and also in making collections from the Indian sellers. So this is the work done by the Indian company. The business operations are not directly or indirectly controlled by eBay India. eBay India has no role in introducing a specific customer. eBay India does not say that Mr. A please go and buy, Mr. B please go and sell. That is not happening. Agreements are between the sellers of the products and eBay Switzerland are entered online without any involvement of eBay India. When I want to put my phone on the eBay, I will have to first register myself as a user of the site, and I will have to say somewhere I agree to the term, which normally nobody even bothers to read. But once I agree with eBay Switzerland. I don't have any agreement with eBay India. And yes, it was admitted that eBay India and eBay Motors are providing exclusive services to eBay Switzerland. So in other words, they are dependent people. Dependent in the sense that they are not independent as opposed to independent. They are very much dependent because they don't have any other customer. But are they dependent people considered as a dependent agency permanent establishment? Both things are different. There may be a dependent agent, but not a dependent, it may not always lead to a dependent agency permanent establishment. eBay India has at no stage negotiated or entered into any contract on behalf of eBay Switzerland. It is not maintaining any stock of goods on behalf of that enterprise. And they are not required to process goods on behalf of eBay Switzerland. So these are the three conditions of the dependent agency PE. Either you should have negotiated with the contract, you should have maintained the stock of goods, or you should have processed the goods. Here nothing is happening, and therefore, yes, you are a dependent agent, but you are not a dependent agency PE, and therefore you are not taxable in India. That is what the tribunal came to the conclusion. So the tribunal came to the conclusion that you are basically providing a market platform which is like a marketplace, and it is not FTS, it is not business, it is business profits, but there is no DAPE, and therefore because there is no PE, you are not taxable. The fixed base PE obviously is not there because there is no place of Switzerland in India. So all those other issues were not even pressed by the department. Only issue which was pressed for PE was the dependent agency, which was also held in favor of the taxpayer. What are the other similar transactions online, or means this was one example of a retail trader, another example of auction site, but otherwise in digital marketplace you have apps, you have games, music, movies, books, voice over internet protocol, in-app purchases, and so on. So basically, who are the market players in the digital market? The publishers, the marketplace, the data centers, the intermediaries, and the point of sale. These are the five different people, and one will have to see what role each one of them is playing and where he is playing in order to decide whether his income is taxable in India or not. You have to bear in mind the distinctions between a reseller and an agent, whether there is any royalty for the content, there is a global revenue sharing model, there is a transaction side, there is e-payments, virtual currency, and so on. Take another example. I have tried to keep some examples so that we can identify and try to understand the principles in a focused manner. X is a resident of USA who is visiting India. Before he left the US, he downloaded an app for the Delhi street maps for $2. He has a roaming data connection with AT&T, and during his visit, X downloads an application for the best places to eat in Delhi for $3. So he is downloading apps. One he downloaded outside India, another he downloaded in India. X has an option to pay for the app using his credit card on record with the marketplace, or adding the amount to his AT&T billing. So he has got an option, either he will pay by a credit card which is already there on record, or he can ask AT&T that you add it to my bill. So whichever way, A is committed to pay. Both these apps which he purchased were published by an Indian developer who is based at Bangalore. The developer is entitled to 70% revenue share from the global sales of his app on the marketplace, and he receives a consolidated payout every month. Let us say there is some website in the US where this app has been put up, or iTunes or Play Store or wherever this is put up. He has got a rev share agreement with that party, and whatever the amount is realized by either iTunes or Play Store, 70% of the revenue comes to the Bangalore based developer. The marketplace acts as an agent for the developer who continues to be liable to pay any taxes applicable on the transaction. So if there is any VAT liability on the transaction, it is the duty of AT&T to collect it and pay as per the applicable laws. So in this case, when Mr. A is paying that $2 in USA or those $3 while he is in India, is it taxable in India? Is it business income or is it royalties? Same questions will arise each time: business income or royalty, or fees for technical services, and whether any withholding debts, and so on. These are the questions. So now I think with this background I will expect answers from your side. whether this $2 and $3 is it income, something which is taxable in India. First of all, let us look at the nature of income, whether it is business income or royalty or service income. Business, there is no royalty involved. You are downloading your product, a copyrighted product for your own use. So there is no royalty involved, there is no service involved, so it is business income. And one transaction was done in the US, another was done in Delhi. Whether the income arises for either of them in India, here we are talking of income arising to the AT&T, because AT&T is collecting those $2 and $3. Back to back, it is an arrangement, that is, we will look at that separately. In neither case it arises in India, because it is a download of the app, and the business income and the the server from which it is downloaded is not located in India, and therefore there is no permanent establishment, and therefore there is nothing, no, even if there is a Apple has a PE in India, there is nothing which is attributable to that PE for this transaction, and therefore it is not taxable. Therefore there is no withholding tax liability. Who does the invoicing is not relevant, there is no tax liability, and profit attribution also will not arise. Now we look at the second leg of the transaction. iTunes or Google Play Store will share 70% of that total collection on a consolidated basis. This is $2 and $3, but in a month, let us say they collect $5,000 from several different customers. So out of that $5,000, 70%, that is $3,500 will be paid to the Bangalore-based developer. So can we say that out of that $3,500, 70% of these $5 is earned by the, why not? Two separate agreements, the source of income is different, and you cannot go to the source of source, so to say, to use the terminology of the tax law, you cannot go to the source of source, and therefore there is no tax. But on a moral or a ethical perspective, should India have the right to tax it? Why was the app developed? First of all, for the purpose of people coming to India. Okay, now that Bangalore based consultant will come to a person like you, and you will say that, oh, why you are taking that income in your personal capacity in India, why don't you form a company in Bermudas or Bahamas or wherever, and you get all these 3,500 every month from different parties in that country, and therefore there is nothing taxable in India. So this is the weakness of the current system, because it is very easy to structure a corporate in any of these tax havens, and you have an arrangement that the money is earned directly by that company, and you don't get anything in India. Back to back, you may do some billing to the extent you require the money for your subsistence in India, but otherwise the bulk of the income you can keep outside, and one fine day you decide that that company will do some investment in India, so money can come to India as an FDI. And that is why the governments have woken up. Now we will go to the much discussed advertising on the internet. We will look at why and how of the internet advertising, what are the different pricing models, difference with the traditional commerce, taxability, and the conclusion on internet advertising. This issue has gathered lot of importance in recent times because of several rulings which have come in the recent past. In fact, I think it was in 94 or 96 when I was required to issue the withholding certificate for the Yahoo case, where the remittance was made by Yahoo India to Yahoo China, and whether that is liable to withholding. We will discuss that when it comes to it. And of course, now with so many precedents, it is very easy to come to a conclusion. In those days, with internet also being what it was, connectivity being what it was always a challenge to come to some conclusion. But it's a matter of pleasure that after so many years, the certificate has been held to be valid by the higher authorities. And the view which I took in those days was that it is not taxable, has seen the light of the day. People have increasing access to the internet through home computers. Before this, let me just a word from FIT, because I'm here representing FIT, Foundation for International Taxation. We have recently started a library at our office at Nariman Point in Mumbai, where there are some very good books on international taxation available. We also have access to the IBFD and the Taxman databases, and these are available free of charge to any person interested in international tax. You just have to go there and register yourself as a member with some proof of identity and certain other things. It is only a reference library. Books are not allowed to be taken outside, but something which will be quite useful if you have interest in the subject. There are many good books on the subject of international tax, as well as these two very good databases. So if anybody wants to do any research, or anybody wants a specific or a general study, this is a opportunity which is, I'm just informing you, it is something very recent. We have yet to do a formal inauguration, but the soft launch is already there. Details are there on the website. You can check out, even the list of books is there. So you can check out the books and you can visit at your convenience. So now back to internet based advertising. People have increasing access to the internet through home computers and mobile devices. Statistically, more time is being spent by consumers on the internet or mobile devices than on TV. There is a proven benefit of more eyeballs per dollar on the internet than TV. After all, when you are advertising, what you are looking for is eyeballs, and if you are getting more eyeballs on the internet, you would try to concentrate more on the internet rather than on the television and other traditional advertising medium. The revenue was 37 billion in US alone, with 40% estimated, additional 40% outside of US, and growth was expected at 15% for the next few years. Traditional advertising on TV or banner or billboards has a local or static audience, whereas internet advertising has the potential global audience and potential global tax presence. This blurs geographical boundaries as to source, service and attribution. What is the source, where the service is provided, how do you attribute the income, all that has got blurred because of this sort of advertisement. And recent issues around the Amazon, Google and the other is because of this. So what types of ads are there on the internet? One is the search ads. Advertisers are to bid for keywords. Depending on the bid value, the ads of the advertisers will be placed at high or low position and along with the search results. So there is always a online auction going on between the advertisers and the publishers, and you always have to bid a particular price. That if my price is, let us say 10 cents or 10 paise, whatever it is, whichever currency. If my price is higher than the other prices at that particular moment, my ad will be displayed first. If mine is 9 paise and somebody has bid 10 paise, his ad will be published first and I will be number 2 and so on. So this is something ongoing, this process is going on, and based on the auction the positioning is decided. And this sort of advertising is predominantly used by search engines like Yahoo and Google. And there are players like Right Media Exchange, which is similar to Bolt, where these sort of auctions keep on taking place online. There is a Right Media Exchange, like we have the National Stock Exchange, the Bombay Stock Exchange, where different websites and different publishers register themselves that I have got so many, whatever unit is that. And it varies with the time of the day of the week, the season, the prices keep on varying. And there is a bid and call, and ultimately a deal is struck, and thereafter so when you go do a Google search on, let us say, international tax in India, there will be 10 or 20 different players who will be competing for your eyeballs, and somebody may bid 10 paise, somebody may bid 20 paise depending on their interest in you, and that is how you will come to know who is number 1, who is number 2 and number 3 when you do the Google search. Then there are other ads like the display ads, usual form of banners that are posted on designated or agreed websites. So you have a website, let us say indiatimes.com, and there you have a banner ad which may be by any corporate, let us say it can be the Hindustan Unilever, which is a Lux display, or it can be any other. So that is a banner ad. Generally these banner ads are compensated on a per month or a per period basis. And with the agreement with the advertiser, the websites can be local or global. It can be, you can put an ad, let us say you can put an ad on Yahoo Ireland's website. If you think that you are a great tax consultant and you want to attack the market of Ireland, you can put your advertisement over there, and perhaps our institute's rules also will not apply there. So there are these different pricing models, cost per mille or cost per 1000 views. So when you are having this display views, so this obviously 10 paisa is a unit, but ultimately it is per 1000 views you are going to pay the price. The advertiser pays Yahoo or Google based on the exposure which the user has on the ads. This revenue is shared between Google and Yahoo, between the online publisher, where the website gets paid through the click ad. So this is a different model. This is a different model. If I want to put an ad on Yahoo and Google, I don't want a 10 paisa or 20 paisa commitment. I will say that if I get a click to my website, only then I will pay, and I will pay you based on per 1000 views to my website from your search engine. And that is how the revenue is decided and shared. Sometimes it is on a transaction basis, sometimes it is a cost per click. So simply because somebody goes to a website through me, then the revenue is generated, or sometimes it is only if the transaction is fructified. So these are the different ways the advertisements are structured on the internet. But still we have got a long way to go, that somebody orders a pizza on the internet and the delivery is online, it comes by an attachment. That is still a long way to go. Maybe with the 3D printers which keep on hearing nowadays, that day is not very far, but currently this is a very long way to go. E-commerce still has to overcome the physical barrier. The trade in the tangible property, payment and processing can happen online, but the seller will still have to physically deliver the goods. For services also, there is a physical location of rendering the services. I am sitting in Bombay and I am giving an opinion to my client in New York. So my location is identified and I am doing the work. But as far as online advertising is concerned, the advertiser and the service provider can be based in a given country, but the users who click the ads and view the ads can be based anywhere in the world. Google is in Ireland, advertiser, let us say it can be Coca-Cola of USA, but it can be used by any person from any country. And essentially the reason or the cause for the revenue can be overseas, but the financial transaction can happen, let us say, in India also. Let us say if Coca-Cola India has given the ad to Google, payment will be made by Coca-Cola India to Google, but that ad of Coca-Cola can be viewed by any user from anywhere in the world. So that blurs the distinction of what is the source, whether the person making the payment, like in our income tax law, section 916 and 917 and 915. The deeming fiction is that person making the payment, if he is from India, then the income is deemed to accrue or arise in India. Here, even if the payment is made from India, it might be actually arising elsewhere. So these all traditional rules have gone for a 6. The service provider may provide the service in US, the publisher may be registered in country A, servers which host the ads may be located in country B, users who click the ads are in country C, the goods may be manufactured in country D and shipped from country E. So there are at least half a dozen countries involved in the transaction, and each country will say that something has happened in my country and therefore I want to tax it. And obviously each person will do an allocation in a way that the total of 6 is going to be more than the total profit earned by the enterprise at all. An example of advertisement, HCO is a company resident in state S and operates a number of hardware stores in Midtown, the largest city in state S. Midtown is a city, state S, HCO is a big company resident. In order to better target its advertising, HCO has concluded an agreement with ARCO, a resident of a low tax jurisdiction, that is a subsidiary of large multinational that operates widely used internet search engine. The search engine developed by ARCO is offered free of charge to individuals and institutional users. Based on the frequency of searches and the previous searches made by individual users, ARCO is able to offer to companies such as HCO a very well targeted advertising platform. And ARCO derives 95% of its revenue from selling, from doing this online advertisement. So there is a standard agreement concluded between the ARCO's portal and HCO that it will pay 10 paise or 10 cents or whatever is the currency, wherever they are located, it can be any currency, on a cost per click basis for having its ads displayed in a result pages for a number of keywords such as somebody puts search of keywords like buy tools in Bittown. Somebody, because HCO is dealing in tools, so it has selected such keywords. So for such keywords, if anybody displays wants a search, the advertisement of HCO will come alongside, and the cost of that is 10 paise, let us say 10 paise or 10 cents, whatever, and HCO agrees to pay that amount each time an internet user clicks on one of its ads displayed on the search results. When an auction system used by ARCO determines where the ad will appear on the page displaying the results of the search. For example, if 10 paise is the highest ARCO has got at that time, it will be the first ad in respect of this buy tools in Bittown. If it is there somebody has made 11 paise, then that will be number 1 and this will be number 2. But ultimately, if somebody clicks through that ad and goes, then this 10 paise charge will accrue. In 2002 or 2012, HCO paid a total amount of 10 million, whatever, dollars, rupees, whatever, to ARCO pursuant to this arrangement. The tax administration of state has denied deduction of that amount based on the argument that HCO should have withheld tax on the amount because ARCO's income is taxable in state S, and the argument of the revenue are like this, that ARCO has a permanent establishment in state S, or the payment to ARCO is a royalty, or the payment to ARCO is a fees for technical service, or lastly, ARCO is not entitled to the benefits of the SR treaty because it was set up in state R only for tax reasons. So these are the 4 reasons taken by the revenue authorities of state S, and they say that you should have withheld tax, and because you have not withheld tax, I am not going to allow you deduction. Similar to something like our section 40A. What is the answer? We have got this right florist decision, Kolkata Tribunal, similar facts, where instead of the tools it was the flowers in Kolkata was the keyword, and it was held to be not taxable. It is neither business income, there is no permanent establishment, there is no royalty, there is no fees for technical services, and the treaty being there, you have to respect it, and therefore you are not, in that case it was Google was held to be not taxable. In the Yahoo India ruling, the Mumbai ITAT has held that Yahoo India's payment to Yahoo Hong Kong for a banner advertisement would not be taxable as royalty, as the service did not involve use or right to use any industrial, commercial or scientific equipment. Here the facts were like this. ITDC of India approached Yahoo India that they want to put up an advertisement on Yahoo China's website, that if you come to India, these are the places to visit and so on. These are the hotels, and some such banner was put up, and for that ITDC India paid to Yahoo India for putting up the advertisement on Yahoo China's website. It was not at all displayed on the Yahoo India website. So Yahoo India collected that advertisement, whatever the digital format of the advertisement, and it was passed on to their Chinese office, and they displayed on that. As per the internal arrangement between Yahoo, certain percentage of the advertisement income which was arisen to Yahoo India was shared with Yahoo China, because after all Yahoo China is going to do the work and they are going to display the ad. So there was a revenue sharing arrangement between Yahoo India and Yahoo China, who were 2 separate companies, though they were part of the same group. So Yahoo India paid this amount to Yahoo China, and the tax department took the view that when you paid this amount to Yahoo China, you should have withheld tax, because there was a royalty, because it involved a use or right to use some equipment. They could not specify which equipment, but basically they were trying to say that the website is an equipment, and the tribunal held that this argument is not right, and no withholding was required, and the payment was rightly done without any withholding. Following this ruling, the tribunal again held that the payment to Google Ireland was not in the nature of royalty or technical service in the FTS in the case of Primstone Technologies. So that was a case where payment was not made between two group companies, but an actual user like Right Florists and Google Ireland. In the Right Florist ruling also, the Calcutta Tribunal held that payments to search engines such as Google Ireland and Yahoo USA for online advertisements are not taxable in India either as royalty or FTS or as business profit in the absence of any PE. The tribunal emphasized that there were no servers of these e-commerce payees in India, and therefore there is no PE in India and therefore not taxable in India. In contrast, earlier there were some rulings like in Galileo's case that a website does trigger a PE, but now the current thinking is that these websites do not constitute a PE. My reading of these judgments is that here the tribunal, all the three tribunals have proceeded on the basis that the servers were located outside India. There was no finding of fact by the assessing authority that the servers are located outside India. In practice, what we know is that mirror servers are located all over, and it is also possible that some of these mirror servers were in India. So what is going to be the final outcome? Because I read somewhere that Right Flourish, the department has gone to the High Court. So what is going to be the final ruling? Because what is the exact location of the server is something, I think perhaps that is the decisive factor, and if the server was in India, perhaps the answer can be different. Another example connected to advertisement, an ad aggregator in Switzerland. A Swiss company identifies various sites on which advertisements or links of ICO can be arranged by them. There is an Indian company which engages a Swiss company to identify on which sites the advertisements should be published. ICO will approve the sites and provides the material for the ad banners or the URLs to be linked to the Swiss company. Swiss company releases such advertisements on the sites as agreed. The Swiss company is paid on a per click basis, and the number of clicks during a period are aggregated, and payment is made by ICO to the Swiss company. The payment made by ICO to Swiss company is complete payment for the transaction, and the payment to the ultimate media or the site is an arrangement between the Swiss company and the website. So here there is a per click basis of revenue, but there it could be some other basis of revenue. Here it can be 10 paise and there it can be 1 paise, because this guy is an aggregator. So if he is guaranteeing large volumes, he will get different rates. So that is his profit. So how the advertisement, the website or the company which owns the website where the ultimate ad is released is something decided by the Swiss company, and it is a separate contract between these two parties, and there the Indian company does not even know how much has actually flowed back to India. Swiss company operates from Switzerland and is a tax resident of Switzerland. The work of identifying the sites and coordinating it is done by the Swiss company from Switzerland. The sites where the advertisements or links are arranged are having their servers outside India, and the work is expected to be done by the Swiss company outside India. They have also confirmed that they do not have any PE in India through which the work is done. So if we were to analyze this transaction under the domestic law, first let us look at the business profits. The entire services or operations are rendered from outside India, and the consideration is also paid outside India. Therefore, under 911, one cannot say that there is a business connection in India, especially with reference to advertisements displayed on sites where the servers are outside India. Again, we can rely on the Right Florist case or the other two cases which we discussed. If we try to look at the royalties, There have been decisions of AsiaSat and other cases where it has held that such payments are not in the nature of royalties. In 2012, we have had a series of amendments in section 916. The definition of royalties has undergone a change. We have got explanation 4, 5 and 6 inserted, and it will remains to be seen whether post amendment the new definition of royalty and the explanations, whether that will overrule the AsiaSat and other decisions which were held holding that it is not in the nature of royalty. So far as fees for technical services, there are a series of judgments which can be of help to say that it is not in the nature of fees for technical services and therefore not taxable. So this is the position under the domestic law. Business income not there, royalty perhaps, FTS not there. So now we examine under the treaty. So this is how we normally proceed with a situation in real life. First examine under the domestic law, and then you look at the treaty, and then you come to the conclusion that whether you can argue it is taxable or not taxable. So here, because under the domestic law royalties there could be a exposure because the of the amendment of 2012. Let us look at the treaty. The wording is more or less similar to what is there in the definition of royalties under the Indian law. The term royalties as used in this article means payment of any kind received as a consideration for the use of or the right to use or any copyright blah 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 etc. So wording is more or less similar, but in the domestic law we have got explanation 4 and 5 in section 916, which explanations are conspicuous by their absence in the treaty. Explanation 4 and 5 are giving certain specific extended meanings to the words which are defined used in this definition. So whether these additional words in the explanation, whether these can be extended to the treaty or not, was a question in a couple of issues. WNS North America, as also Nokia Networks and Before You International, and in all the three cases it has been held that the extended definitions do not apply, and therefore in spite of the amendment of 2012 explanation 4 and 5, the extended definitions will not go to a treaty case even though the wording is identical, because that explanation is missing in the treaty. It is there only in that. So when you look at that, yes, it is taxable, but if you look at the treaty, this explanation not being there, you will look at the normal meaning and therefore you will not try to hold that it is taxable under the treaty. Just one rider. Very recently, I think last week, I believe it is Mumbai Tribunal which has held in the case of Viacom 18, where it has held that if certain words are not defined in the treaty, under article 3(2) of the treaty, you will need to go to the meaning given under the domestic law. And therefore, if words like process etc. which are used in the explanation 4 and 5 are defined in a particular manner under the domestic law, that definition will need to be extended to the treaty. So this is a new round of litigation which is going to take place. We have got 3 decisions favoring the SSC. Very recently that one of the tribunals has had against, and this is going to go on. This Tom and Jerry game is going to continue for a long time till we come to some conclusion whether this amount is actually in the nature of royalties or not. So far as the other FTS, obviously there is not applicable. Business profits also not applicable because there is no permanent establishment. Again, the question of if the server is in India has not been looked at by any of the rulings, and that also could change the answer. So one can conclude that traditional source rules or the PE rules may not be suited to determine the taxability of the advertisement income. There are decisions in countries like Germany where a mere server can be treated as a PE, especially an intelligent server has been held to be a permanent establishment. Italy is in the process of introducing what is known as a Google tax, that if you advertise something on Google, you pay some tax. Especially these certain economies which are known as the pigs economies of Europe. You are aware of which are the pigs economies? Yeah. Portugal, Italy, Greece and Spain, which are at the bottom of the economy in Europe. They are now looking at any and every way trying to increase their collections, tax collections, and therefore they came out with this Google tax. Of course, there has been a lot of opposition, and I read about 2 or 3 weeks ago that Italy has decided not to introduce this. But more and more countries will think of such options, and till the OECD and BEPS and all those G20 results come out to some conclusion, these sort of attempts are going to be done. Even India has got a retrospective change of definition of royalties. So even India is not sitting cool. We also have these amendments at explanation 4 and 5. And maybe over time, we are going to get more and more Viacom 18 type of decisions rather than the WNS and the Nokia which we saw, because on a plain reading perhaps that is more convincing, because terms not defined in the treaty, there is a specific article 3.2 that you go to the domestic law, and domestic law, if it defines in a particular manner, you have to go to that definition. And maybe dangerous for corporates if individual countries begin to tax these incomes, and it will have a cascading impact, and the businesses are going to be significantly impacted by this taxation. Or right now we have a case of perhaps double non-taxation, but we will soon be having a case of multiple taxation. More and more countries will try and tax the same income. So now on the internet, more and more people are doing more and more things. You are playing interactive games, watch live sports, find a personal relationship through the internet. We have got websites like shadi.com and jivansathi.com and so on. Store data on the cloud, use computer software stored on the cloud, and no software is downloaded on the machine. Means you are just doing cloud computing. You are not storing anything on your server. You are just doing everything on the cloud. Nowadays, we were also involved in one of the cases where companies providing software as a service in respect of payroll processing. The entire data is on the cloud. The client does not have to purchase the software. He just has to have a login ID and upload his employees' data, and at every month you will get the payroll. Employees will also get a login, so they can see their income details, their tax details, and so on, whatever is required or whatever is agreed. And everything is happening on the cloud. There is nothing which is happening. Means nobody is buying any software, nobody is buying any server space. You are just having a pay by use, per employee per month certain amount is fixed, and that covers the entire service cost. So more and more business models are being developed, and each model will have a different way. For example, this company which I am mentioning currently is based out of Bangalore. But what stops it from opening a subsidiary in, let us say, Bahamas or Bermudas or wherever, and provide this service through that company, and therefore it will not pay any tax in India. One more example, hire a cloud. An Indian company obtains the following services from a US company, namely space on the server of a US company as may be required by ICO from time to time. ICO, let us say ICO is in the business of doing this payroll processing. It does not want to buy the server. It will go to a US company which has a server, and it will pay by use of the server space. Today I am having 1 GB, tomorrow I will need 2 GB, then 10 GB, whatever, depending on my clients. As and when I get more clients, I will pay for more space. Today I will pay only for 10 GB or whatever is the agreed amount. When I buy the server space, I also get RAM on the server as may be required from time to time, because without the random access memory, the server cannot be really used. It will also get the incidental operating systems to enable the use. It will also provide the connectivity for enabling the Indian company and not the customers or vendors to use the above. ICO uses this service either to provide a platform from which its customer, through intermediaries such as mobile phone companies, download games. So what ICO is doing is to use that server to have a website from where its customers will be able to download games, or for usage as a social networking sites where its games will be available free of charge to users. Games are available free, but ultimately there is a social network inside, and on that you will generate some advertisement revenue. So that is the business model. So this server space can be used for anything. I mentioned about the payroll processing. So you can use that server space for anything. So now whether this payment for the server space, whether it is taxable in India, again one has to go follow the same procedure, look at the domestic law under the Act. We have got decisions like Asia said, etc., where it is held to be not royalty. Post 2012, there could be an issue. Fees for technical services, the same set of decisions, it is not in the nature of fees for technical services. Business profits, again there is no server in, no permanent establishment in India, therefore not taxable. Again the same analysis, explanation 4 and 5, whether they will apply or not. Again we have got this Nokia and before you cases and now the Viacom cases, so the same answer. Facts are different, but the law is the same, the answers are the same. Any questions? See, ultimately what is happening is that each different set of facts we are analyzing with the same set of law under the domestic law and the treaty. Treaty may be different, but by and large the treaty wordings are comparable, and maybe they may be having a tweak here or there, but by and large you are having the same analysis, and the conclusions you will follow the same set of rules to come to the conclusion. And till the 2012 amendments, the conclusion in India was that it is not taxable. Now perhaps it remains to be seen whether it is taxable or not. You have had enough of examples, or one more example of a matrimonial site? Let us just have a look at this example, and then we will go to the BEPS report. Mix and Match is a website which allows single men and women to find long-term relationship. Potential clients are first required to complete a long and detailed questionnaire. Using algorithms developed by Mix and Match on the basis of research of shared values and features of happy couples, Mix and Match has got a proprietary software which analyzes the responses to the questionnaire and compares that summary with other summaries in the website and identifies potential compatible summaries and notifies the potential client of the possible matches. A potential client who wants to communicate with a possible match must open an account with Mix and Match, which requires the payment of a monthly fee, which is auto renewed. Obviously these people will keep on charging you till you say no, and the account holder is then given access to the secure communication system through which the communications with the possible matches take place on an anonymous basis, because initially you don't want to disclose your identity, you just want to test the waters and try to see whether you are really compatible or not. So what is happening is something comparable like this. There is a state B from where the boy comes, he fills up the online questionnaire on the site, on the cloud, which is on the cloud. There is a state G from where the girl comes, who also fills up the questionnaire, and the website identifies a possible match and the subscription is paid. Once the subscription is paid, what is going to happen is that the two will communicate with each other through the secure mode first, and thereafter if they decide that yes, they are worth meeting, they will meet directly, and if all is well, they may finally conclude the relationship. So this is how the transaction takes place. A very simple transaction, two potential candidates who find their soulmates through the site. Obviously this sort of payment to the website, the subscription, nobody is going to claim it as a deduction for their so section 40A will not apply, but whether the Mix and Match, does Mix and Match Inc., which is in state M&M, have any taxable income? Ultimately the same analysis, royalties, fees for technical services, business, whether there is PE or not, and again same questions, are cross border payments made in these cases taxable? Is there a PE? Is there any royalty? Is there any FTS? And of course, the answer we all know. So, what is the way forward? One thing is very clear, that the current rules are inadequate to deal with these situations. The income is positively arising in both the countries where the boy and the girl are residing. Without the boy and the girl, the M&M site would not have been there. And if the site was not there, it would not have earned any income. So, it is definitely earning income from these people all across the globe. There are programmers who would not have earned their salaries because they are developing these algorithms, etc., to do the matching and compatibility analysis. But today, who is paying taxes? At least not M&M. The programmers might be paying tax in their home country on their salary income. So, Arvind Skar has said that conclusion is that the effects of a PE concept in the international fiscal law have changed, in particular during the last few decades. Rather than protecting the tax base in the source state, the PE principle has become instrumental in ensuring the avoidance of the source state taxation for some economically important business operations. In fact, in 1997 at the IFA Congress at Delhi, Professor Dunberg highlighted the inadequacy of the PE concept for taxation of e-commerce transactions. And therefore, time is ripe for developing or modifying the concept of PE and taxation of income from new business concepts to avoid these disputes. Even the 2001 High Powered Committee report of India also said the same thing. But till that time, people are going to rely more and more on the internet for doing whatever, even simple things like communication. If I want to hand over a piece of paper to him just across the table, I will not do that. I will send him a mail and he will keep on shouting till he gets that mail, because that is the way business is done nowadays. Now, few words on the BEPS report and how the analysis or what is the possible course of action in future. The draft report has analyzed how does the digital economy leads to base erosion and profit shifting. One way is that minimization of taxation in the market country. See, everybody realizes that the income is where the market is, but for the purpose of taxation, income is where the residence is. That is the principle, and therefore, by avoiding a taxable presence, or in the case of a taxable presence, by shifting the gross profits via trading structures or reducing net profit by maximizing deductions at the level of the payer. So, ultimately the objective is to minimize the tax in the source country. Another objective is to have low or no withholding tax in the source country. A company in the digital economy may be entitled to reduce withholding tax because digital economy, it is very easy to indulge in treaty shopping. You can easily form a company with a jurisdiction where there is a favorable tax treaty. For capital gains, there have been, we are saying lot of use or misuse of the India-Mauritius treaty, but there the money is actually flying through Mauritius. Here, you just form a company in whichever jurisdiction you want, depending on which treaty you feel is more beneficial to you, and then you route the transactions through that company. So, it is more and more easy to have a situation of low or no withholding tax. So, even if you have a situation that under the treaty Viacom 18 decision is finally upheld, it is royalties, you will find out treaties, countries where the treaty is there and the rate of tax is either nil or it is the minimal, and therefore again the source country does not get the tax it really deserves. Next is low or no taxation at the level of the recipient. You can have hybrid entities and so on. So, you pay the money to an entity, but that entity is not taxable in that jurisdiction. This is another form of treaty shopping where you combine the treaty shopping with the domestic law. And another domestic law, that particular entity, we have this, some countries do not tax the partnerships but tax only the partners. So, you have a partnership in that country and the partners are outside, and so on. So, you do all sort of hybrid entities or hybrid instruments and try to siphon the money or shift the profits to erode the basis. And you also apply the mismatch of the hybrid instruments and application of preferential domestic tax regimes and payments to deductible payments to related entities in low or no tax jurisdictions. See, these are all detailed concepts. I will not be able to go in detail at this time, but I am just highlighting that this sort of planning is going on, and that is what has been identified by the OECD. No current taxation of low tax profits at the level of the ultimate parents. Rashmin Bhai mentioned about the Google, which is paying full tax on its US profits, but no tax on its out of US profits. Why? Because all these profits are earned by Google Ireland, and Google Ireland does not declare dividends. The shares of Google Ireland are held by Google US. So the minute Ireland declares dividend to US, it will become taxable in US. But there is a permanent deferral. Google Ireland is never declaring dividends. It is plowing back the money in further investments across the globe, but not in US, and therefore there is a permanent deferral. So this way, USA has the strictest CFC regimes, but still Google is succeeding not paying tax, because there are certain lacuna in the CFC regime of USA, which it is taking full advantage. In fact, when there was a public inquiry, a Congress inquiry done by the US for Googles and the Amazons and the Apples, and the CEO of Apple was summoned at that Congress committee, and he has gone on record to say that as a CEO of Apple, my job is to maximize the value for my shareholders and not to pay the maximum tax to the government. So they are quite clear that what I am doing is within the four corners of law, and if USA is not getting the tax, so be it. So the principles are very clear, and that is in fact aggravating more and more the problem of this BEPS. In UK, of course, we all know that Starbucks ultimately paid some tax, a few billion pounds to the UK government because of the public pressure, because people stopped going to Starbucks because of the picketing, and it was getting a very bad publicity. So instead of facing this bad publicity, they decided to pay an X amount to the HMRC that we are paying voluntary tax. Whether it can be called a tax or a gift, nobody knows. But Starbucks had to go down to that level because otherwise its market share was suffering. And therefore, there are these four options suggested in the draft report of the BEPS on the action plan number 1. One is to modify the rules of exemption from PE. Currently, we have got the rules for PE which refers to the brick and mortar economy. You need a fixed place of business. So now they are thinking of some amendments to the rules of what will constitute a PE. They are also thinking of creating new rules based on significant digital presence. So if you have significant digital presence like Google has almost in all the countries, then perhaps it is taxable. They are going to come out with a concept of virtual permanent establishment. So you don't need a fixed place, virtual presence is good enough. And creation of a withholding tax on digital transactions. Now withholding tax, generally OECD is not in favor of more and more reliance on withholding tax, because generally what happens in transactions is that withholding tax is pushed on to the customer. In all agreements you will have a clause that the payment mentioned above is net of all taxes. So the withholding tax is to be passed on to the customer, so that it becomes an indirect VAT. So you already have a VAT and you are having this indirect VAT. So OECD is generally not in favor of withholding tax, but maybe this time they are considering that also. So I think with that I will conclude my presentation. If there are any questions, you can ask me. So either it was very good or very bad. Everybody has understood or nobody has understood. Okay then, thank you.